attorneys. I want to welcome you to the Tennessee Court of Appeals. This morning, your panel consists of Judge Frierson, Judge Davis, and myself, Judge McClarity. I assume that the appellant has already made the reservation of your time. Is that correct?
Yes, Your Honor. Okay.
And I've been asked to remind you to sort of keep close to the mic as you present your argument. My technician told us this morning that yesterday we had a walker-talker, and unfortunately we weren't able to keep up with him with his arguments. So this morning, if you sort of keep close to the mic, it will be a bit benefit for us. Are the parties ready and prepared this morning? Then, Madam Clerk, will you call the first case?
Payton Castillo versus David Lloyd Riggs et al.
For the appellant. You may proceed.
May it please the court. My name is Kara Weiner, and I represent Memorial Hospital. Today, we will be splitting the argument. I will be taking the first 9 minutes. Mr. Miles will be taking the next 3, and we will be reserving 3 for rebuttal. This is a healthcare liability matter regarding the scope of protection afforded in Tennessee Code Annotated 6811-272, also known as the Tennessee Peer Review Law or the Tennessee Patient Safety and Quality Improvement Act. TCA 6811-272 expressly recognizes that peer review activities must be protected from discovery to allow healthcare providers to freely and candidly discuss patient care in order to improve outcomes, patient safety, and improve quality. And providers must be able to do this without the fear of it being used against them in litigation. In order to effectuate that goal, the legislature enacted a broad statute that protects both direct and indirect discovery of quality improvement activities. TCA 6811-272 also protects any and all statements made by a healthcare provider related to quality improvement activities. The protection is not limited to statements made in a committee meeting or during the actual review. Instead, the statute protects statements related to QIC activity, even if those statements occur outside the QIC committee itself, as is the case here. Had the legislature only intended to protect statements made during the quality improvement discussions or the process itself, it could have so limited the protections. Instead, the statute broadly applies to any and all statements related to quality improvement activities. And it does this because allowing discovery of peer review or quality improvement committee activities to be discovered in litigation would chill the peer review process itself.
Okay, I have sort of a practical question. In this case, the candor meeting happened, statements were allegedly made at the candor meeting, and the way it came about was, I think the plaintiff sent discovery to you guys. Maybe it was request to admit what was said at the candor meeting. And that's where the objection was filed?
There were 2 instances, Your Honor. There was both written discovery that was sent, and there were deposition testimonies of Dr. Codsey and Jessica Stanley, both of whom were based the information that they gave regarding the quality of care on QIC information.
Okay. And you're saying you can't make those people provide that information or provide that testimony because it's protected by the QIC. But is there anything, let's say we get to trial and the plaintiffs want to testify and say, hey, we had this meeting and these folks said to us, you missed the bleeding. Is there anything, are you saying that this prevents that as well?
It would, Your Honor. I think admissibility of the evidence and discovery is in the same sentence in TCA 6811-272. And so it protects both the discovery and the admissibility, so yes.
So everything said at the candor meeting, you're saying, is non-discoverable, non-disclosable as testimony?
Everything said at the candor meeting that was based on the QIC review.
Which is pretty much everything.
Which is pretty much everything, but we're not trying to keep the candor meeting itself from discovery. Dr. Kazi testified there were discussions involving the patient's artwork that were outside QIC reviews.
Super relevant.
But anything based on the QIC privilege would be protected.
So basically, if the plaintiffs get up there and testify, they simply cannot say anything. They cannot say, oh, the person, I can't remember the name of the person who attended the candor meeting, but they flat out said the doctor missed it, and we're sorry. That's not coming in.
That is true, Your Honor.
Okay.
And Powell and Pinkard both have held that this is an unwaivable privilege, and I think that's vitally important to the analysis from this court. Because unlike other privileges, such as attorney-client privilege, both Powell and Pinkard have said that this is not a privilege held by one person. This is not, the hospital itself, who I represent, doesn't hold the privilege. The purpose of the privilege is to protect the entire peer review process. So if we were to allow one person's disclosure to waive the process, then the whole peer review would fall apart. And so that's why it's so vitally important that both Powell and Pinkard have said that there is no waiver.
It sort of seems, though, that there's sort of two competing interests here. You've got the interest of getting to the bottom of what happened, quality review on the part of the hospital, which is the point of the QIC. And then you've got the candor meeting, which is a different, has a different purpose, which is sort of to, for lack of a better term, smooth the waters with the patient or patient's family, or actually give them some answers and some transparency. But if that's the goal of the candor meeting, then that goal is subverted when none of that can then come in. So do you agree with me that there's sort of competing interests between QIC and candor meeting?
I understand your point, Your Honor, but I don't think it's necessarily a competing interest. I think it's sort of a twofold answer. One is that we are part of QIC reviews is to make the hospital safer, and educating patients has been shown to make the hospital safer. So it is part and parcel of the QIC review, even though it in itself is not a QIC function. But also I think it's really important to look at TCA 6811-272A, because the state of Tennessee legislature has recognized how important this particular interest is. So even if there are other interests, 6811-272A says it's the policy of the state to encourage the improvement of patient safety, quality of patient care, and evaluation of the quality, safety, cost, processes, and necessity of healthcare services by hospitals, healthcare facilities, and healthcare providers. Tennessee further recognizes that certain protections must be available to these entities to ensure that they are able to effectively pursue these measures. And I think that is the most important interest, is to ensure that not just this hospital, but hospitals across Tennessee are able to engage in honest, serious review of what occurs at the hospital without fear that that will eventually be brought up in litigation.
Excuse me for interrupting, counsel. What does your client assert as being the purpose of the candor meeting?
The record shows that Ms. Stanley testified that the purpose of it is to educate the family about what happened, to tell them what occurred. There is Ms. Stanley cites in her deposition to a website, which is not part of the official record, but it shows that candor meetings do overall improve patient quality and safety.
What about the source of the information that is required to be disclosed? Does that have a bearing on it?
The source of the information? Mm-hmm. I think that's key, because what's protected, Your Honor, is direct and indirect discovery of QIC activities. And Dr. Kadzi's specific...
No, that's not what I'm getting at.
I'm sorry,
What
Your
I'm
Honor.
getting at is, not getting at, what I'm wondering about is the source of the QIC information was gathered from the original source, and I assume that the original source would be the hospital records. Is that correct?
Correct. The original source records are certainly available. Those would include the CT scan at issue, the medical records. What then subsequently happened is there was a discussion or discussions about those records. We're not trying to protect the records themselves. Plaintiff certainly has a copy of them. And if they want to depose nurses or providers who were there treating the patient as part of the original source of what occurred, they can do that. What is prohibited is the Quality Improvement Committee discussions, not the original source itself.
Their opinions from the original records as a result of what they analyzed from the original records. Is that what's involved here?
Yes, they're healthcare opinions that were at least based on part on the records.
So they used that in both meetings. They used it in the QIC meeting, and they used that opinion in the Cantor meeting also. Is that correct?
They disclosed the opinion of the results of the QIC. That's correct. I don't know if they went through the records themselves at the Cantor meeting, but they certainly discussed the results of the QIC and peer review meeting.
But was it their opinions that you're trying to prevent from disclosing?
Yes, it is the opinions of the QIC committee. So the findings of the quality of health care that was rendered to the decedent, Mr. Castillo. Not what occurred, but the opinions of the quality of health care that was rendered is what it is that we are trying to protect.
Okay, you have your time for rebuttal.
Can I ask one more question, Judge McClarty? And I know your time's up, but it seems to me that the result of this is you've got the hospital saying in a meeting, we know we messed up, and we think it's important to tell you that we messed up, but we don't want you repeating that we messed up in the event that you sued us. And is that good policy, or do we even need to look at that as policy? Is that beyond our scope?
That is absolutely good policy, Your Honor, because we're encouraging honesty. We are encouraging. I would dispute slightly exactly what was said at the Cantor meeting, but even if it were those words, we are still encouraging the review from the hospital and then the disclosure to the families of what occurred. And should this court find that this policy is waivable, that somehow repeating the results of a QIC meeting is waivable, then it will make hospitals and healthcare providers think twice about engaging in these reviews and informing patients about the quality of healthcare that was rendered. Thank you.
Good morning. My name is Eric Miles. I represent Dr. Rex and the virtual radiologic defendants. Dr. Rex is a radiologist. He's not employed by the hospital. He did not participate in the Cantor meeting. This case is about an allegation that Dr. Rex failed to diagnose an internal hemorrhage on a CT scan that was obtained in the hospital. And he is the first named defendant in the lawsuit. We're here today because a different party, the hospital, elected to have a meeting with the now plaintiff, Mr. Castillo's wife, and have a discussion about the hospital's findings in the QIC proceedings. It is transparent what the plaintiff is attempting to do in a legal proceeding, which is to utilize the hospital's QIC process against a different party, Dr. Rex. Now, it is true that the hospital is a defendant in the lawsuit, but they are the last named defendant. My clients, I believe, are the first 5 named or 6 named because they named 5 different entities. The protections afforded to the QIC process are precisely for this scenario. The reason it cannot be waived, the privilege cannot be waived, is to protect people like Dr. Rex. The court in Powell, which was a 2010 case that predated the current version of the Act, but the current version of the Act is very similar to the previous one, noted that the proper functioning of the process hinges on the assurance to all persons participating in it, including the persons under review. That would be Dr. Rex in this case. He is entitled to the privilege just as the hospital is entitled to the privilege. In this instance, the privilege would be utilized, if waived, the QIC information would be utilized against a person who did not participate in the proceeding that forms the basis for an argument of waiver. So it is our position on behalf of Dr. Rex that this is a vital issue, not just for the hospital. It's a vital issue for the physicians who are being reviewed. It's a vital issue for those who are doing the reviewing. The people who were involved in the QIC were not the people in the Candor session. They were asked to give transparent evaluations and opinions of the care at issue. And now they are facing a scenario where those opinions could be given light in a legal proceeding directly contrary to the language of the Act. Thank you.
Thank you, sir. Okay. Yes, sir. Will there be two arguments on this side?
No,
just
Your
one.
Honor. Sorry. No, Your Honor, only one. Your Honor, my name is David Ward. I, along with my partner, Alex Michelle, we represent Payton Castillo, the wife of the Marshall Castillo. Let me start. It's funny. You draft these outlines and you spend a week doing it, and then you get up here and it's really useless because the questions and the arguments take you different places. Let me start with the last argument first.
However you.
I'm sorry?
However you want to.
Okay, I want to start with the last argument first, which is Dr. Rex's argument that we, the plaintiff, intend to use anything that was used in the Candor meeting, and I think I can give him some peace today. Whatever was said in the Candor meeting, any implication that from the hospital about what Dr. Rex or what Dr. Rex did or didn't do cannot be a substitute for the proof that's required under TCA 2926-101 et sec. We have to come up with expert testimony against Dr. Rex. That's not what our intent is with it whatsoever. So that's not it. He's entitled to that privilege, and that's not what we intend to do with it. Where it could be important, and ultimately, as your honors know, evidence can run in multiple lanes. It can be different places. But for the hospital to tell our client, Payton Castillo, to bring her in 2 weeks after her husband has passed away and tell her what happened, and then later tell her, you can't know that, you can't rely upon that. If you ever mention it, you're violating a privilege. First of all, let me back up. Marshall Castillo went into the hospital on January 3rd, early in the morning. There was a CT that was done early in the morning. He was sent home at 9:47, discharged. He was back in the hospital at 1:12, and he passed away. He was pronounced dead at 1:48. So this all happened within the course of about 12 hours, more like 7. 2 weeks later, the hospital called and said, we'd like to engage in a Candor meeting. Mrs. Castillo goes to the hospital. She takes her mom and her dad. The hospital, it's Tony Houston, which is the COO. It's Dr. Kodzi and Jessica Stanley. And they've taken her deposition, Payton Castillo, and she's testified that what they told me was that the CT revealed an internal hemorrhage, and they should never have let my husband go home. That upset her. It would upset anyone. Then ultimately nothing followed on with the Candor meeting, and there was no ultimate resolution. Candor stands for communication and optimal resolution, but there was no resolution. We filed the lawsuit in a timely fashion. The answers roll in, and everything about internal hemorrhage and it's all denied. And we share that with our client, and she's a little upset because everything she was told is now denied. Now, I understand pleading practice. Our client, however, doesn't understand it quite as well as we do. And so she starts asking questions. So we take the deposition of Dr. Kodzi. Well, first we take the deposition of Jessica Stanley. She tells us that she, in preparation for this Candor meeting, only reviewed emails And I think she talked about candor process materials. And Dr. Kazi said he only reviewed really the hospital records. They didn't talk to anybody. They could have told us that they talked to anybody from the QIC meeting. They didn't. They apparently didn't participate in the QIC meeting itself. Dr. Kazi, of course, ultimately produced an affidavit. He doesn't say in his affidavit, I was in the QIC meeting. I participated. I reviewed materials. I actually reviewed materials from. There's this term, based on. Based on is a very, I mean, when you're the master of your affidavit, you can say whatever you want. You need to say what it is you mean. And if it's, I reviewed QIC materials, it needs to say, I reviewed QIC materials. I spoke to someone. The things that were going to be said were actually quotes from the QIC. That's not what happened. That's not what he says in his affidavit. He says it was based on, which apparently, when I'm drafting an affidavit, I do the best I can do. Apparently, that's the best that could be done. But the problem is, this court has told us multiple times, if you want to know what a statute means, read the statute. 6811-272 deals with a QIC meeting, a QIC proceeding. It doesn't deal with a candor meeting. It doesn't give protection to a candor meeting.
Excuse me for interrupting,
Yes, Your
counsel. What does your client assert as being the purpose of the candor meeting?
Well, to be honest with you, she just knew she was going to a meeting. Now, the hospital told her that they wanted to tell her what they had found. That's basically what she testified, and she went. So as far as what she knows about the purpose of a candor meeting, I think Judge Davis has the right concept, though, that the hospital does this to either smooth the waters. There are other states which have candor statutes. Now,
you referenced candor
Yes.
acronym as including resolution.
Yes.
Is part of the purpose of this forum to settle this case?
You mean
A candor meeting.
is a candor meeting in other states typically what it is? And when I say other states, this is our first case, my first case in 35 years of dealing with a candor meeting of any type whatsoever. And so I'm telling you simply what I know. And so there are other states. Colorado has a statute where you can have a candor meeting, and it talks about the hospital can tell the family first, you need to bring a lawyer. Everything we're doing here today is privileged. You're never going to mention this to anybody. Here's the documents you're going to sign.
You're referring to the candor meeting.
Exactly. Now, I'm also speaking of Colorado, and you're not going to talk about this. And at the end of it, they tell them this is either a case we think that we need to pay you on, or we don't. And that's the way the Colorado statute works. Georgia has one that's in the works, but it's not there yet. So this is sort of a nascent process, which is why this is a very dangerous process here, because what we're doing is we're taking look, 6811-272, we all know what the public policy is. It's a good policy. The things that happen in a peer review process should remain there, but when the hospital takes it, what we have all for 30 years, it's been an internal hospital process, quiet, nobody knows about it, and we turn, and now we make this open process, and we take what we've learned, and now we're using it for whatever purpose the hospital is using it for, and now we want the court, we want this court. Judge Hollingsworth was faced with this decision. We want the court to take what is a very powerful privilege, and we want you to cloak a candor meeting with what the legislature cloaked a QIC meeting. He refused to do so because it's basically extending a privilege to where the legislature simply did not go. And it's not the same public policy. The public policy of 6811-272 is so that physicians, hospitals can internally review, assess, and improve. But a candor meeting, that's not the purpose. It's a different purpose. It doesn't improve patient safety. We can come up with some study somewhere perhaps, but that's not the purpose. 6811-272 is that's the public policy. And one other argument that I think is interesting is that it applies to all and everywhere. Well, if we read the statute, the second part of 6811-272C1 says any person who supplies information, testifies, or makes statements as part of a QIC. So it's as part of. And then in section, this statute is replete with a language that talks about that what is protected. What is protected is records of a QIC and testimony or statements made to the QIC in a QIC. And so, for instance, Section D says to a QIC. D1 says to a QIC. Section F says to a QIC. In fact, in 2014, if this privilege is so broad, in 2014, the legislature actually went back and amended it to say, hey, this hospital's QIC can give it to this hospital's QIC.
Under what authority is a candor meeting established?
In the state of Tennessee?
Correct.
There is none. Not that I'm aware of. It's certainly not one of the...
How does it come to be?
Well, in this case, Memorial Hospital decided to have one.
There's no statutory authority for it.
There is no statutory authority for it in the state of Tennessee.
Is it just individual hospital policy? And so presumably not every hospital does candor meetings or has.
In fact, Jessica Stanley said in her deposition she didn't even know if Memorial Hospital had the candor policy on their books yet. It was a nascent process there. And so she couldn't tell us what, we asked them what the purpose was, and they really couldn't tell us. Dr. Kazi, to be fair, Dr. Kazi said that the purpose was to share information with the family. Jessica Stanley, who's the head of quality there, said that the policy, she wasn't sure that it was on the books yet. That's why we have a problem with this being this very powerful privilege being applied to what is, in essence, going to be a piecemeal process across the state. A hospital here in Knoxville could have one policy, one in Memphis could have another policy, and you don't know, and you wouldn't know what's going on. And this has certainly never been considered by the legislature.
Are there settlement statements made during the course of a candor meeting?
I don't have reference to answer your question. In this situation, simply what was told was what was found, and what they shared information. They talked about some artwork, and they talked about. Well, to be honest with you, that's one of the other issues in this case. Each one of the depositions that was taken is about 25 pages long and replete with objections that were based on 6811-272. So I actually don't have a lot of information about any of this material because we were cut off early. Now, I understand that from the defense standpoint, asking for the protection. But to answer your question, in other states, we actually have legislative outlay telling what to do. Here in Tennessee, we have nothing. We have no guidance from the legislature whatsoever.
Are there any cases from the Sixth Circuit that address this issue?
I do not know. I am not aware of any.
Thank you.
If anyone has any other questions.
I hear none. Thank you.
Thank you.
Your rebuttal?
With respect to the question that Judge Frierson just asked, I'd like to address the Gautreaux versus Chattanooga-Hamilton County, which is the Erlanger case. In that case, it was based on a settlement agreement, and the court found that a resolution of privilege issue which culminated in a settlement agreement was protected by peer review laws and not subject to an open records request. So a settlement agreement that came out or was based on a QIC was subject to the protection of the QIC and the peer
And that
review.
case is included in your brief.
Yes, Your Honor.
Thank you.
It's the Gautreaux case. I wanted to quickly address and dispose of the arguments that Dr. Codsey and Ms. Stanley were not basing their information on QIC. Dr. Codsey specifically testified that he reviewed documents, including medical records, as part of the quality evaluation of the case. He also confirmed under oath when asked if he had information about aspects of what was discussed with Payton Castillo at the meeting that he knew, quote, about the aspects of quality evaluation. Therefore, Dr. Codsey specifically testified at his deposition twice he was directly involved in the quality evaluation. Jessica Stanley testified that she'd only reviewed documents related to the candor process, but that was after she was instructed by me that she should only reveal documents other than what she reviewed pursuant to quality and peer review. So that was the answer, but it was subject to my instruction. But I think an important thing that this court needs to consider is that TCA 6811-272 protects direct and indirect discovery. Opposing counsel read the second half of the statute, but the first half is vitally important. It says records of a QIC and testimony or statements by a healthcare organization's officers, directors, trustees, healthcare providers, administrative staff, employees, or other committee members or attendees relating to activities of the QIC shall be confidential and privileged and shall be protected from direct or indirect means of discovery, subpoena, or admission into any judicial or administrative proceeding. So there are two important parts to that, to subsection C1. First is it just has to be related to QIC activity. So the purpose of the candor meeting isn't what matters. What matters is that it relates to the QIC, as evidenced by Dr. Codsey saying all of the information we told her about the quality of care rendered was based on QIC. But it goes further than that, and it also says that it protects from direct or indirect discovery. And what plaintiffs are attempting to do here is indirectly get the results of a peer review that they would be forbidden from getting directly, because they can't directly ask the results of a peer review. Thank you, Your Honors.
Thank you. Thanks to both parties for your presentation. Your case has now been submitted to this court for review. You should receive our opinion within a due period of time. Thank you very much.
Thank you.
The attorneys may be excused.